friend, today, as it is mentioned, I'm going to, let me tell you, I started my career in somewhere in 1988. And since then, it has been almost 32 years in this particular profession. And what I observed right from beginning of my career, that the research scholars, because as a by the grace of God, I got a wonderful opportunity to work in various affiliated colleges. I mean, one affiliated college. Later on, I went to a couple of universities in this country, and then I was really fortunate to be a part of a couple of three to four foreign universities as well, in various capacities, in the capacity of visiting scientists, research scholars, and visiting professor as well. So while going through all this journey, I was really fortunate to have interaction with research scholars, master students, bachelor students, and faculty members as well. And I have seen them from very close proximity. And whenever I seen them from very close proximity, forget about foreign university. I'm talking. Let me start from very rural. Very small college from rural area. Like the students who are there doing their undergraduation or post graduation, they always come up with a wonderful, one or other innovative experiment during their tenure. But unfortunately, since as they are not aware about this intellectual property, somehow they are not able to protect. Somehow they are not able to encash them. But before I start, let me, with the permission of chair and with permission of organizer, I would like to share my screen, and then it will be easier for you to yeah. Yes. So I was talking about the experiences which I had with the students. So when I had had a wonderful interaction with students, I came to know that the students are doing one or other innovative experiment during their undergraduation, post-graduation. But unfortunately, since they are not aware of this IPR, what this intellectual property is all about, how it is to be protected, and how it can be encashed. This can be a wonderful source of wealth, but unfortunately we are not aware of that, right? So as a result of that, whatever we are doing, whatever the students are doing at their remote places, it is it's going to be wastage for them. Of course they are going to have wonderful learning experience, but only having experience is not going to serve the purpose. We need to whatever experiences we have, we need to convert that experience into knowledge, and the knowledge should be converted into some sort of wealth, right? And this is where it is lagging. The same experience I had with the faculty members also, when I had interaction with the many faculty members across the country, like those who are working in affiliated colleges or universities. Like whenever you are working at your place, whenever you are doing some experiment in the laboratory, one or other teacher in every lab, every college, they always come up with some innovative idea to do the experiment. Like whatever experiment that have been included in the curriculum, there would be one or other teacher in each and every colleges, and he is going to have altogether innovative idea, and he is going to implement that, and he is going to show it to the student. But unfortunately, still that efforts are not being counted. That efforts are not being converted into knowledge, and later on, they are not somehow they are not able to convert that into the wealth. Same thing is, if you look at the copyright, this I was talking about patent. If you look at the copyright, unfortunately, I would say is very fortunate that most of the teachers, whether it is like the college from metropolitan city or remote place, every teacher, and particularly the teachers from social sciences, they will be having a wonderful record credits of their wonderful record of book writing. I'm sure, like whenever I had that experience like couple of years back when I was leading IQAC of my university, when we were going through the preparation of data for SSR, I was very happy that whenever I came across the criteria 3, that okay, how many copyright you have with your university. So I was very happy. I was very excited rather. I thought like most of the teachers I know, they are having a bundle of books with them. They have written many number of books, like subject related books, poems, and all those books with them, and I'm sure like I will be having overflooding of copyrights with me, right? But unfortunately, when I went to each and every faculty member, I came to know that very few of them were having copyright of their own books. Although they were, although most of us, most of the faculty members, most of the teachers were writing many number of books, we have wonderful records with us. But unfortunately, if I ask you like how many copyrights you have, then question will be either no or maybe very few out of like even if you are having like 20 books with you, maybe you are having 1 or 2 copyright with you. The reason for that is we are not aware. क्योंकि क्या होता है ना, हम किताब तो लिखते हैं, but once we write the book, we always go for very like easy option, right? So we always choose the publisher who is going to provide us free copies, or who is going to publish our book free of charge, and then later on we never know how much money he is going to earn, right? He is earning, we are least bothered because we are happy with that, with that recognition only, that we have published these many number of books. I mean, why I'm referring this, like during these last 32 years, what I seen is, since we are not aware, I said we because I'm also from the same fraternity, since we are not aware of this intellectual property, unfortunately, we could not convert this property into wealth. So we need to have, therefore, this kind of creation of awareness is going to be very important. And I'm sure I have seen many brochures and in many webinars during this pandemic time. There have been like many, there are many colleges, they have conducted this kind of awareness session. Today is not only awareness, we'll be focusing on drafting as well, because today I will be highlighting how this intellectual property is going to be important, and how, because let me be very honest, it would be very difficult for me to cover all the aspect of this IPR. So I will be focusing mainly on patent and copyright, and then almost 30 to 40% of my allocated time I will be spending on how to draft at least provisional specification. Forget about complete specification, because I may not be able to give you the detailed glimpses of the complete specification, but at least I'm going to tell you how the provisional specification can be drafted in due course of time. So to begin with, let us disclose because whenever we are talking about property, first of all, let us disclose what kind of properties we have. Okay, so let us disclose. So we are going to have fixed properties. We are very aware of this. We have land, we have flat, we have bungalow. These are called immovable properties, a fixed property, a stationary properties, which cannot be transferred from one place to another. And we have got portable properties, right? Like we have a smartphone, two-wheeler, this laptop, like four-wheelers, furnitures, these kind of portable properties we have. So these properties are called as tangible properties. Why this is called tangible? Because the tangible means the property which can be touched upon, which has got physical existence, right? That is what we call as tangible property. And one of the beauty of this tangible property is owner enjoy exclusive right over the same. This is one of the beauty, right? Like for example, if I'm having four-wheeler with me, and if I want to sell four-wheeler to my friend, and if I go ahead and said, okay, my friend, this is what my four-wheeler is, and I'm going to write it down on one plain paper that I'm handing over this four-wheeler to you, and this is yours now, right? So he's not going to trust upon me, right? He will be very outspoken. He will be coming to me and he will say, okay, nothing doing. Let us go to RTO office and have a proper registration. It means like whenever we are selling and whenever we are buying these tangible properties, we are very much sure, we would like to be very much sure that we should have an exclusive right over this property, right? We are very much concerned about the exclusive right? This is the beauty of this tangible property. However, the intangible properties which I am going to tell you now, we are very least bothered about the intangible properties. Like what is intangible property then? The property which cannot be which may not have physical existence. Of course, product is going to be physical existence, but property on its own cannot have a physical existence, right? Which we cannot touch. What is this property? This is what the intellectual property is all about. The property which is represented by product that is outcome of human mind and intellect and creativity, right? So whatever creativity we have, whatever intellect we have, out of that, whatever it is creating, it could be book, it could be research article, it could be product, it could be process, whatever, right? And some of the examples of invention, I'm going to tell you the difference between invention and innovation as well. Invention innovation, it could be like original design, trademark, artistic creation, geographical indicate. I mean, even under the geographical indication, you can have some sort of right on with you, like that can be considered as asset. But unfortunately, we never consider this as an asset. We usually consider, this is how, unfortunate part is, I will very recently, not recently, long back, I gone through that book, Rich Dad Poor Dad. Many of you must have gone through that book, Rich Dad Poor Dad. What is the difference? I gone through again, because long back, maybe when I was doing my post graduation, I still remember I gone through that book. But very recently, I gone through that Rich Dad Poor Dad book, which was written by one of the very successful businessman, Robert Kiyosaki. He talked about like asset. He talked about the difference between poor man and like rich man. A rich man always, whatever income the rich man is having, he always spend that income. He always, invest that income for creating assets. But as far as the poor or ordinary man, you individuals are concerned, what we do, usually whatever income we have, we always, use that income for creating liabilities, right? Like kind of luxury items like four-wheeler car, like home, like this is again debatable, right? Truly speaking, whenever we are constructing house, by the mercy of, bank loan, whether it can be considered as asset or, liabilities. Truly speaking, it is liabilities, truly speaking. So the rich man always create asset, and that whatever income he is generating, whatever, revenue he is generating from asset, is going to be used for, having the luxury item, right? However, the poor man always use his income for, purchase of, luxury item, and he is keep on adding the liabilities only. So unfortunately, this invention, this intellectual property, although it is asset, so far we were not aware. And therefore today, first of all, I'm going to create some sort of awareness that this is going to be asset for us. This asset can be like wonderful for us to create, develop a wonderful wealth out of this. And then, then I will be telling you how patent can be drafted and all those details. Whenever we are talking about assets, like as it is mentioned by, as I mentioned by, mention about the tangible properties, like we always have the exclusive right of the tangible properties. Similarly, we need to have some sort of means, rather legal, some means that can be used to safeguard this intellectual property. And whatever intellectual mean, whatever right which we are going to use to safeguard our intellectual property is nothing but the intellectual property right. So today we are going to speak on, we are going to discuss on the various issues of intellectual property right. So let me first of all tell you the difference between invention and innovation. Invention is always a creation of product or introduction of process for the first time. Like whenever you are first time creating some sort of product or some sort of process, it is being referred as innovation. But wherever, like as far as the innovation is concerned, whenever you have an improvement or a significant contribution to existing product or process, that is what we call as innovation. It means whenever you are developing product first time or processes first time, that can be referred as invention. And whenever you are having significant improvement in your already existing product or already existing processes, that is nothing but innovation. Truly speaking, over the time, this definition has also been modified. Truly speaking, nowadays innovation means like it should be novel, like whatever improvement you are doing, that should be novel, then it should be non-obvious, and it should have some industrial application. It's not only that, because this is what the patent talks about. Like the requirement of patent is the idea should be novel, it should be non-obvious, and it should have some industrial application. And nowadays, let me tell you, my friend, truly speaking, innovation means like it's not only application. So whatever the stakeholders, whatever customer you will be focusing on, unless you satisfy the full expectations of the stakeholders, this innovation, this the new product can never be considered as innovation. So nowadays, in present context, whenever you are talking about innovation, it means it should be novel, non-obvious, have industrial application, and you should have a processes, that continuous processes rather, to fulfill the expectation of your stakeholders like customer. Then only it can be referred as innovation. Now, let me tell you, because I'm going to quote you some example of invention, like for which we are very much familiar with. Like हमें पता है कि थॉमसन एडिसन ने इलेक्ट्रिक बल्ब को इन्वेंट किया था 1879 को. अलेक्जेंडर ग्राहम बेल invented the first practical model of the telephone in 1885. Marconi has invented radio in the year 1890. These are some of the milestones, I would say. Wright brother have invented the first world successful motor operated airplane 1905. And there are some notable individual contribution as well. Like whenever we are talking about tabla, हमें उस्ताद जाकिर हुसैन याद करेंगे हम. पेंटिंग, लाइक जब भी हमें पेंटिंग दिखाई देगी तो एमएफ हुसैन साहब दिखाई देंगे. Singing, although there are many singers nowadays, but still in singing, Lata Mangeshkar has created her own space, right? Similarly, A.R. Rahman, वो कहते ही वो musician दिखाई देंगे, and obviously whenever you are talking about missile, APJ Abdul Kalam. So these are some of the examples I have quoted, but in continuation with this, as I mentioned earlier, like there are many teachers, many faculty members during the day-to-day college or university work, they are coming up with some innovative ideas, some innovative experiment. But unfortunately, due to because of awareness, lack of awareness, we are not able to encourage this. Number one. Number two, like the many faculty members, as I mentioned earlier, they have wonderful record of books writing, publications, but unfortunately very few of them will have the copyright, and they could convert that into the wealth, right? Now the question is why I have quoted these examples, because whenever we talked about invention, it's not only invention. Like once you have invented something, you need to protect that. Unless some of them have protected and they become a rich individual in the country, and many of us have not somehow, due to lack of awareness, could not protect those intellectual properties, and as a result of that, we could not convert that into the wealth. So intellectual property is like another asset. As I mentioned earlier, it is like another tangible. This is, although it is intangible, but this is like an intangible tangible asset. It can be bought. Like a tangible asset, it can also be bought, it can be sold, it can be mortgaged, it can be licensed, it can be exchanged. But we are not aware. जैसे कि हम किताब लिखते हैं तो हम क्या करते हैं कि एक किताब, कोई एक पब्लिशर है, एक बार हमने लिख दिया किताब, एक बार पब्लिश कर दिया, थ्रू आउट लाइफ ही इज गोइंग टू सेल, थ्रू आउट लाइफ. हमें पता भी नहीं वो कितना पैसा कमा रहा है, पता भी नहीं. रादर अगर आपके पास कॉपीराइट होता तो क्या कर सकते थे आप? यू कुड हैव सेल दैट कॉपीराइट ओनली फॉर 5 years ड्यूरेशन, राइट? 5 साल के लिए आप सस्ता बेचिए. वंस यू बिकेम अ वेरी फेमस ऑथर, देन you can dictate the terms, right? Once you have become famous author, later on, because you have sold, you did that transaction only for initial 5 years. Later on you can change, you can mortgage that, you can license that, you can exchange that, whatever. So provided we need to be very sure about this, right? If the owner acquires legal right over the property, he becomes exclusive owner. And then we are talking about, that is why we are talking about IPR today. So IPR is going to provide us legal right, and it's going to provide us possible rewards as well. Possible rewards is not only recognition, it's not only social recognition, rewards in terms of money as well. That is why it may become a source of national wealth. Because if you are becoming rich, obviously your country is going to be rich, right? So therefore, we need to be very sure about what kind of intellectual property we have, how to protect that, and how to convert that intellectual property into wealth. So whenever we are talking about intellectual property, there are two different kinds of intellectual property: industrial property and copyright. So as far as industrial property is concerned, we can have patents, designs, trademarks, and geographical indications. But like this is, as I mentioned earlier, this topic is going to be very, very vast. It requires at least a couple of days to finish. Let me tell you, my friend, if you really want to study this in detail. And therefore today I will be focusing only on one of the aspect of industrial property, patent. And as far as copyright is concerned, there are many like writings, books, research article which is very much close to the teacher fraternity. So I will be spending little time on the copyright which can come from our writing of books and research article. Musical work, dramatic works, painting, drawing, sound recording, broadcast, artistic performances, all can be copyrighted. There are three different kinds of the major IPs, like functional and technical invention, which comes under Patent Act 1970, which was amended later on in 1999 and 2005. The purely artistic work, as I mentioned earlier, like particularly as per the teacher fraternity is concerned, we can focus on the books and research article, which comes under Copyright Act 1957 originally, and later on amended 5 times in 80, 82, 84, 92, 94, and 99. And as far as symbol, logo, word, sound, color, design, all those are concerned, it comes under trademark, right? Trademark Act 1999, and which was also amended later on 3 times in the subsequent years. Let me spend some time on copyright to begin with, क्योंकि मुझे पता है कि हमारे teachers जो क्योंकि today, because for this today audience, I know the most of us are in the the colleges and universities, right? So copyright and patent is going to be our area of concern. So I will be focusing more on copyright and patent only, right? So what is copyright? Copyright this is a definition by Oxford English Dictionary: exclusive right given by law for certain terms of years to an author, composer, or his assignee to print, publish and sell copies of his original work. देखिए, क्योंकि हमारे पास copyright इसीलिए नहीं है, इसीलिए we cannot publish that, we cannot print that. Even if you are author, you don't have right to take the print. Let me tell you, my friend, it will go against you will be violating copyright, because जब आप किसी कोई पब्लिशर आपका किताब पब्लिश करता है, तो what he is going to do? He is going to take the copyright by his name. So you are not sometimes you are going to get royalty maybe for 1 or 2 years. कभी कभी देता है वो, लेकिन most of the time we don't get royalty as well. But if you are having copyright with you, let me tell you, my friend, you can dictate the terms. आप रॉयल्टी क्लेम कर सकते हो कि भाई 5 साल के लिए मुझे इतना रॉयल्टी चाहिए, उसके बाद मैं डिसाइड करूंगा कि मुझे क्या करना है. बट फॉर इनिशियल 5 years, बिकॉज यू कुड बी इन द बिगिनिंग फेज ऑफ योर करियर. उसके लिए कुछ मेरे सजेशंस है फॉर द टीचर्स दोज हु आर राइटिंग बुक्स. लेट मी टेल यू व्हाई, लाइक मतलब क्यों हम मतलब हमारे किताबों का कॉपीराइट हमारे पास क्यों नहीं होता, उसका रीजन मैं बोलता हूँ. व्हाट वी यूजुअली डू, वी स्टार्ट राइटिंग द बुक्स. once we finish the book writing, and once we have the once we do the proof corrections and all that, then we keep on searching the publishers, right? And we approach publisher that who is going to publish your book. And the publisher who is going to publish your book free of charge, you are going to most likely we are going to prefer that publisher, right? तो क्या होगा, अभी प्रॉब्लम कैसा है कि पब्लिशर ने आपको कमेंट किया, क्योंकि आज तो अभी अननोन थे आप, यू वर नॉट वेरी फेमस, आप बिल्कुल नए थे, आपकी कोई रिकॉग्निशन नहीं था, आपकी कोई इमेज नहीं थी मार्केट में, तो उन्होंने क्या किया, आपको फ्री ऑफ चार्ज आपका किताब पब्लिश कर दिया. नाउ अभी क्या होगा उसके बाद में, like maybe for आपको लगेगा कि यार this is going to be good opportunity for me because he is kind enough to agree to publish my book without charging anything, so you will be excited and we are going to hand over the entire right to him. वो कॉपीराइट पे अपना सिग्नेचर, आपका सिग्नेचर लेगा, खुशी खुशी आप सिग्नेचर कर देंगे. एंड लेट मी टेल यू माय फ्रेंड, इफ आपका किताब अगर अच्छा है तो विद इन 1 or 2 years it can become popular, right? तो बिकॉज उसके पास अपना खुद का नेटवर्क होगा, एंड देन वंस इट इज पॉपुलर देन he can start earning money. Rather, what you should do, let me tell you my friend, this is what I started doing now, after 32 years of experience. Obviously I am also from the same fraternity, right? I learned through the experiences only. तो अभी क्या करना चाहिए आपने, बिफोर स्टार्ट राइटिंग बुक्स यू नीड टू राइट द कंटेंट फर्स्ट. how many content, how many chapters you are going to have, what would be the scope of each and every chapter. Write preface right in the beginning, introductory remark, and send it to the publishers. Not only one publisher but many publishers. Most importantly आपको क्या करना है, सबसे important ये करना है कि whenever you are writing a book, you are going to focus on one particular area, right? So you need to anticipate, like whenever you are reaching to the audience, first of all you need to identify who is going to be your audience. Whenever you are writing book, you need to identify who is going to be your audience, right? First of all you identify the audience, accordingly you start writing your book. And audience, you should anticipate कि when this book reaches to audience, what kind of benefit the audience is going to have. You please anticipate that, the benefit. if you are anticipating benefit, and if you are mentioning it in your introductory remark, and if you are sending it to the publisher, let me tell you, my friend, looking at this content, looking at your own like CV and your own credibility, there will be more than one publisher looking at you. There will be behind you, that everybody will be they will be start asking you, right? But let me tell you again, once you finish your book, don't go ahead and hand over the entire book to any publisher. How? Protect it with Copyright Act. Go ahead and submit the copyright, have copyright with you, and then you can sell the copyright, right? If you start doing this, let me tell you, my friend, you can earn the credibility, at the same time you can earn money as well. So this kind of approach need to be adopted. Unfortunately, most of teaching fraternity, most of us, I would say, because I'm also from same fraternity, हम लोग ये करते नहीं. If you start doing like this, research article का तो मैं समझ सकता हूँ कि because whenever you are sending research article, आपको पता होगा कि वो जो जर्नल का एडिटर जो है आपसे कॉपीराइट पे सिग्नेचर ले लेगा, because there you don't have any option, because in that journal volume is not only your own article, वहां पर बाकी सभी रिसर्च स्कॉलर के भी आर्टिकल रहेंगे. So there I can understand that you have to assign copyright to the publisher of that particular journal. That is fine. But as far as book is concerned, you are sole author, right? You are sole authority. There you should not do any compromise. If you start doing this, let me tell you, my friend, you can start earning credibility as well as the wealth. So what we can protect, as I mentioned earlier, original literally, which include books, which include poems, which include research articles, dramatics, musical, artistic work, films, movies, sound recording. If you are having that sort of like a skill with you, you can go ahead and do that, right? So there are many options available. So as far as the terms is concerned, it depends on nature of how long the copyright, once you have the copyright with you, how long you are going to have that right. It depends on nature of work, but most of the time it is going to be lifetime of the author plus 60 years. You can see, once you have copyright, during your entire lifetime plus 60 years, you can have the copyright. And as far as the broadcast reproduction is concerned, it will be around 25 years. What kind of literary work? Let me tell you more, because I'm going to focus this on more like novels, poems, short stories, books of any subject or of your interest, research articles, and computer program. Those who are from computer discipline, whatever programs, like I saw many teachers, even many master students, they are coming up with their own algorithm, own program to deal with some problem, but somehow they are not getting they are not copywriting it. They are not getting copyright of the own creation, right? So you need to understand that databases. There are many students, they are creating databases, because in my university, fortunately, like when I was IQC director, I came across many students. When we used to have interaction with research scholar, I came to know that many research scholars, they come up with wonderful algorithm, computer students, but somehow they were not aware that it can be protected, unfortunately. Like if you are having the musical department, many students always have some innovative ideas of singing, innovative ideas of composing, that need to be copyrighted. It's not like you cannot leave it in between. And then as far as copyright computer software is concerned, you can have the program manuals, punch cards, magnetic tape, computer printouts to computer programs. And this is all about the copyright. Now I'm comparing this with patent. The title is the why patent don't work, right? Like one of the disadvantage of patent is patent always confirm the monopoly, right? It always exclude the competitor from conducting research. What is the reason? The reason is, whenever if you want to file patent, it should be novel, it should be non-obvious, and it should have industrial application. Moreover, whenever you are filing patent, like for example, if you are filing patent, let us say you come up with one particular device, right? One particular device, and if your jurisdiction is India, so and across the country, nobody else can do that kind of research. I mean, he can do that, but he cannot convert that into the product if you are having patent. So patent is going to provide you some sort of monopoly. So public interest would be ensured if every corporation could prevent anytime, anywhere. Because, again, I'm going to tell you this later. Whenever you are filing patent, you can file patent in the jurisdiction of India. You can file patent in the jurisdiction of beyond the India as well, right? You can decide what would be jurisdiction of your patent. And you can patent it anywhere, anytime, anywhere. It means for 20 years, because most of the time you are going to have right with you for another 20 years once it is granted. For another 20 years it is going to be your own monopoly, right? So in that way it's going to hamper the public interest. And most importantly, no guarantee for independent researcher that their efforts will pay off. The reason is, we never know. Like, if you are working only for patents, you never know whenever you will be submitting patent. By that time you will come to know that it is not novel, somebody else have already submitted, right? And therefore the copyright can be option for that, because here you don't need to have a kind of inventiveness. For copyright purpose you don't need to have the inventiveness. Without inventiveness also you can go ahead and submit your copyright. Now during this technology, because there has been tremendous development in technology also, everything is available on tip of our finger, and as a result of that, infringement becomes a very common problem in every aspect, right? And therefore the copying, like the factor which are determining infringement that you need to understand. I'm going to show a little bit about this. I'm going to tell you a little bit about this. Like whenever we are talking about copying, nowadays, like whenever you are writing paper, also research paper, there also you need to be very sure. You need to be very sure about the plagiarism, right? So whenever you are submitting paper, you need to check your plagiarism, your self plagiarism, as well as the normal plagiarism as well. So as far as copying is concerned, copying can be a casual. It can have a causal connection. It can have subconscious connection. It can have indirect copying as well. Still, it will be considered infringement. As far as substantial copying is concerned, like there are two examples, like unaltered copying. Unaltered means like you have taken paragraph to paragraph as it is, not entire article, but like one paragraph on one article, another paragraph on another article, and this is how you have constructed your own article, right? Or extent of defendant alteration. It means like 100%, like you have not changed anything, right? So this kind of infringement is taking place nowadays. But since it is right, since this is like, if you are having copyright with you, obviously nobody can steal your copyright, and nobody can steal your intellectual property. This is what it is important. What kind of right you are going to have? We are talking about copyright. What kind of right? There would be two different kind of right. One, moral rights, which will protect personality of author. Other is going to be economical right, which will bring you economic benefit. That is very, very important. What are moral right? Right of authorship, right of integrity, like digital manipulation, right of display, right? Truly speaking, like if your आपका किताब है, आपने अगर किसी पब्लिशर के नाम अगर कॉपीराइट है, आप डिस्प्ले भी नहीं कर सकते, आपको कभी कभी पता नहीं रहता, like you don't have right to display also. But if you are having copyright with you, this is going to be the moral right you can have. You can do the digital manipulation as far as the digital copy is concerned, and you can have the display of the books which you are having with you if you are having copyright. As far as economical rights is concerned, this is very, very important. Right of reproduction. This is very important. Making copies. Like today, let us say you have got 100 copies. Tomorrow you can have 1000 copies. That is with you. But if you don't have copyright, you cannot do it. Right? You have to beg. You have to beg to the publisher that, okay, please go ahead and have the more number of copies, and you're not going to get anything out of that. Storage in computer memories. You can have the digitized form and sell it again. Right? Right of distribution, issuing copies. You can have the digital distribution. You can have a digital version of the book and you can sell it. Right of communication to the public performance. What your book you have written, for example, you can have the public performance. Otherwise you cannot do. You see, बहुत बार ऐसा होता है, हमें पता नहीं रहता. हमारा खुद का किताब है, मान लो आपने कोई एक किताब लिखा है, and then you want to have the public performance. If you don't have copyright, you cannot do it. You have to have a proper permission from your publisher. Otherwise, you cannot do it. Otherwise, he can sue you in the court of law. Let me tell you, my friend. So we have to be very careful about that. Internet communication. Then adoption of right, conversion into another form. Like let's say from literature to drama. For example, you have a book in literary form. You can convert into drama. You can do it. You can condense it. Let us say, for example, you have got 400 pages book. You want to make it very condensed form. Another version, condensed form. One is 500 pages. Other is maybe like very condensed form, 100 pages book. You can do it if you are having with you. Picturization, comic format. That also can be done if you are having copyright with you. Right to make cinematograph or sound recording. Translation like Marathi में है, हिंदी में करिए, हिंदी में है, English में करिए. Any languages you can do. Rental, you can rent. Release right to original artistic work. I mean, that also can be done. Resell, I'm talking about resell. Then as far as ownership is concerned, if you are having, if you are talking about literally, author is going to be owner. Drama, dramatistic is going to be owner. Music, composer is going to be owner. Artistic work, artist is going to be owner. Like for example, painter, architect. Photographer is going to be owner. Author of computer program, person who causes the work to be created. Movie producer owner होते हैं. Sound recording के लिए producer होते हैं. But there are certain exceptions as well. Let us say you are employed person, right? So if you are employed in newspaper, although you are writing, you are drafting news, but the owner is going to be employer, the owner of that newspaper, right? Photograph, painting, cinema for valuable consideration, person who pays the money. Let us say you have developed wonderful, like painting, or you have developed one movie, for example, but like somebody pays the money for that, so he is going to be owner of that, right? So there are some certain exception. Lecture deliver in public, the person who is delivering lecture. Government में job करते हो, आपने, let us say you are working in census, right? You have collected some data, census data, and you have your own interpretation, right? But still, although you have interpreted it on based on your own skills, right? Still, you cannot be owner of that, because you are working for the government, because you are paid person, right? Government is going to be owner of that. If you are working in public undertaking, the public undertaking, like for example, university is going to be owner. If you are working for international, like for example, WHO, if you are like WHO employee, and you are doing some important survey of, let us say, COVID-19, right? Out of survey, you come up with your own interpretation. But since you are working for WHO is going to be owner of that property. You are not going to be owner, because you are paid person. So there's another example, like जैसे कि मान लो आपका student है, आप अप्रेंटिस के लिए आप स्टूडेंट को भेजते हो किसी इंडस्ट्री में. सो वट एवर आउटकम यू आर गोइंग टू हैव, द टीचर इज गोइंग टू बी ओनर ऑफ दैट आउटकम, राइट? क्वेश्चन पेपर सेटर होगा, एंड लाइक दैट, राइट? एंड एज पर एज द सिक्योर इन कॉपीराइट इज कंसर्न, आप अगर कॉपीराइट देखोगे 1975 अमेंडमेंट सीरियल नंबर 44 और 45 में आपको डिटेल्स उसका मिल जाएगा. एंड एज पर एज द चार्जेस इज कंसर्न, there are 5,500 rupees, right? This is for license to republish for all literary work, because I'm talking about only the charges of copyright which is related to a teacher fraternity, right? This is for the license for republish 5,000 work, and for having the copyright 500. So 5,500 is only charges you have to apply to Delhi office for as far as the copyright is concerned. Okay. Now, let me focus more on patent now, because patent is going to be one of the very important topic. Now, what is patent? An exclusive right granted by the government to the applicant who discloses his, her, or their invention. Right? So it could be like one individual, it could be a group of people, right? Or you can assign to, like on behalf of you, somebody can submit a patent, right? But the convention can be, moreover again, patent can be granted only for two different things, right? One is product, or it can be processes, right? So let us say for computer program, you cannot have patent. You can have copyright, but you cannot have patent, right? For algorithm, you cannot have patent. For book, you cannot have patent. For research article, you cannot have patent. But for product and processes, right? I am going to tell you what the product means. Like, let us say you have developed one device. You have developed one device which can calculate some very important computation, right? So this is physical device, right? This is, but whenever we are talking about device, it should be new, novel. It should be non-obvious. Non-obvious मैं बताऊंगा आपको क्या होता है, and it should have industrial application. Similarly, processes. Processes means, for example, I'm in steel industry, right? I'm working on one particular material, right? So what I'm doing, I'm by certain combination, by changing the composition, I come up with all sort of different properties of the material. That composite material is going to be altogether different. Okay, and the properties is going to be different. So what I did, I have come up with process. I'm least bothered about the product, because the product may be known product, but this process is new. right? So that you need to understand, like whenever you come up with invention, you need to understand whether you can claim patent for product or process. That you need to understand properly right in the beginning. Now the first is it should be new. Now we know, like most of us, whenever we are submitting papers, research paper to any journal, novelty is going to be one of the key parameter which is going to be tested by the reviewer. Novelty, whenever we are talking about novelty, then you can ensure novelty of your work by doing a rigorous literature review, right? Similarly, here also literature, here is not literature review, here the patent review. Whenever you are talking about novel, you need to do a quick search of patent. I'm going to tell you the website as well, how to do the quick search of patent. So far, whenever you are, the date on which you are claiming, at that time you should be a very first person to claim that kind of invention, right? Either new, altogether new, or you are proposing, or you are claiming some altogether or a significant improvement in some of the properties by doing one or two, by changing one or two parameters, right? Then it should be non obvious. Non obvious का मतलब मैं simple भाषा, simple language में आपको समझाना पसंद करूंगा. Let's say we have got gulab jamun. We know gulab jamun always taste sweet, right? gulab jamun मीठा होता है. मान लो मैंने अगर उसमें मिर्ची अगर भर दी तो क्या होगा? It's not going to be sweet, right? तीखा लगेगा. So it's going to be novel, right? gulab jamun तीखा कर दिया, it's going to be novel, right? So you are going to test the test of novelty. So it is novel altogether. जितने भी गुलाब जामुन है सब मीठे मीठे हैं. My gulab jamun is तीखा, right? So तीखा लाल जो होता है ना उस टाइप का, right? But what about non obvious? It is going to be like non obvious means what? जब आप देखिए non obvious test जो है ना कौन करेगा? The person who has got expertise in that area. The person who has got expertise in that area, he is going to be the test of non obviousness. तो जो सेफ होगा उसको तो पता रहेगा ना, वो कहेगा क्या बेवकूफ बना रहा है. अगर गुलाब जामुन में आप मिर्ची भरोगे तो तीखा ही लगेगा. It is obvious. It's not non obvious. So although it is novel, is going to fail the test of non obviousness. So therefore you need to have the novelty as well as non obviousness of your researcher, of your investigation, of your invention, and then it should have industrial applicability. Industrial applicability means it should have some sort of application, one or other application. Whatever product you have, you need to show that this product is going to be useful for this and this cross section of the society. Unless you do this, your patent is not going to be granted. So this is similar, like like for research paper also, 3 parameters are going to be tested: whether it has got novelty, whether it has got social relevance, or whether it has got the credibility, whether that particular person has some credibility in that area. The same thing is here: novelty, non-obviousness, and whether it has got social relevance in terms of industrial application, whether that can be used to resolve some unresolved issues of the society, right? That kind of industrial application is going to be there, is going to be expected by the patent office. And in lieu of disclosure of invention, government provides legal protection for a limited period of time for your invention. It is going to be usually 20 years. So once it is granted, you are going to get the monopoly of that particular product for over the 20 years of time. This is territorial right in the country where it is granted. So if it is granted for India, so you can have only jurisdiction within India. आप इंडिया में कोई कॉपी उसका कर नहीं पाएगा. Okay, आप infringement में खिलाफ आप कोर्ट में जा सकते हो. But in other country they can do it. So for that purpose, I am going to tell you how to protect that. Now, what kind of protection we can have? No patented invention can be commercially made, used, distributed, sold without patent owner consent. That is very, very important. मैं वही बता रहा था कि हमारे बच्चे क्या करते हैं कि बेचारे बच्चे प्रोडक्ट तो करते हैं, लैब में तो बताते हैं, कुछ कंपटीशन में बताते हैं, जो स्टेट गवर्नमेंट, स्टेट लेवल, सेंट्रल, इंडिया लेवल के कंपटीशन में प्राइज भी लेते हैं. बट अनफॉर्चुनेटली अगर पेटेंट उनके नाम नहीं रहा, ये प्रोटेक्शन अगर नहीं रहा, so other can copy it and they can commercially use it and they can create wonderful wealth out of this. And therefore अगर patent आपके पास है तो nobody can commercially exploit, right? Patent rights are usually enforced in the court that in most of the system hold the authority to stop the patent infringement. जब भी मान लो आपके पास अगर पेटेंट है और आपको पता चला कि somebody is doing some sort of infringement, you can go to the court of law and you can have the complete, you can ask him to recover. Let us say for example आपका कोई प्रोडक्ट है जिसका पेटेंट आपके पास है, किसी XYZ बंदे ने वो पेटेंट का वो आइडिया को यूज करके कोई प्रोडक्ट बनाया and then he got crores of rupees, right? You can get those crores of rupees back to your credit if you go to the court of law. And at the same time, conversely, the court can also declare patent invalid upon the successful challenge by third party. It means whenever you have the patent granted, it is open to everybody. Anybody can challenge. He can go to the patent office and he can challenge your invention. And if he is successful in getting, if the patent office accepted his challenge, then your patent can be revoked, right? It can be cancelled also, right? So that you need to be very careful about. You need to be well aware of. ओनर हैज राइट टू डिसाइड हु, जैसे कि मैंने बताया कि आप उसको आपके पास रख सकते हो, सेल कर सकते हो, किसी को दे सकते हो, राइट? आप किसी को लाइसेंस कर सकते हो, इट कैन बी सोल्ड, इट कैन बी, एंड बट वंस इट इज एज लॉन्ग एज ड्यूरिंग दिस 20 years ऑफ टाइम यू कैन डू वट एवर यू वांट. आप खुद, जैसे कि मान लो आपके पास फॉर एग्जांपल कोविड-19 का आपने कुछ वैक्सीन डेवलप किया, राइट? सो व्हाट यू कैन डू, you need not sell that. You have patent with you, you can start producing, right? You can start production on your own, right? Or because it will be having limited earning, rather than what you can do, you can sell it to India, you can sell it to America, you can sell it to Europe, and you can earn a lot of money. And then maybe certain period of time, that may be 10 years time or 2 years time or 3 years time or 5 years time, whatever, right? And then, but as long as you are having the right, like 20 years, you can have monopoly. But once once the tenure is over, then it will be in public domain. And therefore in pharmaceutical industry, let me tell you my friend, pharmaceutical industry में उनके जो पेटेंट होते हैं, जब भी वो एक्सपायर होते हैं ना, उसके एक दिन पहले से उनकी प्रोसीजर शुरू होती है. So the moment that is expire, on very second moment they are going to file the another patent. That is very, very important. Otherwise there is a lot of significant competition in pharmaceutical, otherwise there would be another pharmaceutical company and he can claim that patent later. Okay, who looks after all these? Let me tell you. Worldwide, let me tell you, every country has their own IP management system. World Intellectual Property Organization, जैसा WHO है ना, वैसा ही है WIPO है. This is a global forum for intellectual property services, policy, information. इसका headquarter Geneva में है. There are certain important milestones, let me tell you, because there was, as far as Universal Declaration of Human Rights was concerned, Article 27 was related to intellectual property, and then the very first convention on intellectual property was held in Paris in 1883. उसके बाद में 1886 में हुआ, and then since last many years, April 26 we started organizing World Intellectual Property Day. So there is kind of awareness creation and kind of milestone in the area of intellectual property. As far as India is concerned, this is the website. You can note down this website, www.ipindia.nic.in, through which you will get what kind of offices you have. We are having 4 different offices: Mumbai, Delhi, Chennai, and Kolkata. You can see the jurisdiction also. As far as Mumbai is concerned, Gujarat, Maharashtra, Madhya Pradesh, Goa, Chhattisgarh, these are the states which comes under Mumbai Patent Office. Like for example, if you want to submit your patent, you can go to Mumbai. But as far as copyright is concerned, you need to go to Delhi, because you cannot submit copyright to Mumbai office. As far as this is very, because from Chandrapur and for your place, this is very close. Rajiv Gandhi National Institute for Intellectual Property Management, which is located in Nagpur. This is the only institute across the country which is providing regular training. This is a training center, right? And this training are very expensive. You can have 1 week training, 2 week training, maybe 2 days training. They are having different packages, and those, if you really want to have a kind of expertise and credential in terms of IP and how IP can be filed, I would advise you to go to this institute and have some short-term courses. There are some international treaties as well. If you really want to enrich yourself, you need to know those treaties also. This convention, as I mentioned earlier, 1883, Berne Convention 1886, and there are different conventions as well. Out of that, you need to know like what those international treaties are if you really want to draft your own patent. There are some IP laws, as I mentioned earlier. Copyright Act. There are this first Copyright Act was there, came into existence in 1957. उसके बाद में काफी amendment हुए. Patent Act 1970 में आया, उसके बाद में काफी amendment हुए. Design Act 2000. Trademarks Act 1999. जैसे मैंने बताया कि I have already mentioned. Geographical indications भी 1999. Because today I'm not going to focus on all those aspects like design, trademarks, and geographical indication because of the the shortage of time. Okay, now you need to understand some. You should not forget these points about the patent. Patent is an exclusive right granted by government to the applicant and or his or her their assignee. You can go ahead, you can have individual patent. Individual author can have the patent. Group of people can have the patent on their name, or you can assign somebody to have patent, right? But the only question is, only parameter is it should be new, non-obvious, and useful means it should have industrial application. Then patent right is granted, as I mentioned earlier, for 20 years. It gives a territorial right and can be enforced only in the country where it has been granted. This you have to be very careful about this. Patent right enables the inventor to decide material benefits. मतलब आपके पास अगर एक बार पेटेंट आता है तो then you will be the exclusive owner of that. Patent right gives protection against the infringement and legal action can be initiated against the unlicensed exploitation. As I mentioned earlier, किसी ने अगर आपका पेटेंट, आपकी आइडिया चुराई, प्रोडक्ट जो आपका पेटेंट है किसी प्रोडक्ट पे और किसी ने उसको कमर्शियली बेचना शुरू किया, you can go to the court of law and you can file the case. Provided right is protected from the terms of the patent, provided that the renewal fees is paid as prescribed. So every year. So that is why it's not a patent. Let me tell you, my friend, maintaining patent is again very, very important. Unfortunately, in India, most of the patents are not commercially viable. That is one of the very pathetic part of the story. Okay. So unless you have but still I would encourage you to go ahead and submit the patent, obviously. But the question is renewal fees. If you don't have any financial, viability of your patent, then how you are going to manage? Because every year you have to pay the renewal fees. Otherwise, it's going to be cancelled, right? Every year if you don't pay that. And most importantly, patentee should be his own policeman. It's not like, for example, I have patent. किसी ने उसका अगर प्रोडक्ट मार्केट में लाया तो पेटेंट ऑफिस उसके खिलाफ केस करेगा. नो, इट्स नॉट लाइक दैट. यू हैव टू बी वेरी वॉचफुल. यू नीड टू सी like what is happening elsewhere, and somebody is exploiting, somebody is unauthentically exploiting your patent. Then you need to go ahead, you need to go to the patent office and submit higher in the court of law, and file the case against him. Then only your right can be protected. That is very important. Now, let me tell you these three criteria. I talked about three criteria. Novelty. Novelty means new. In other words, not known to public in any manner. This is something very different, right? थोड़ा different है क्योंकि जब हम पेपर पब्लिश करते हैं तो वहां पर नॉवेल्टी थोड़ा अलग टाइप्स की होती है. अलग टाइप की इन द सेंस वहां पर पैरामीटर थोड़ा अलग रहेंगे. because there the reviewer is going to see what kind of literature is published so far before that point of time. But here is something different, right? Novelty has to be assessed with respect to the priority date, the date of first disclosure. That is very, very important. That is why there are two ways to file the patent. One is the provisional patent, other is the complete specification. Because the reason is, if you are having something innovative idea with you, very innovative idea, okay, so don't wait for the result. क्योंकि आप अगर रिजल्ट का वेट करोगे तो somebody else may have that idea and he may go ahead of you. So what you need to do, you need to go ahead and file the provisional patent. That is what your priority date, the first date of disclosure. Okay, otherwise क्या होगा, आज के दिमाग में, आज जैसे कि मान लो आज आपके दिमाग में इनोवेटिव आइडिया आई है, and then you started thinking, did experiment, got product, and then you thought of submitting patent. By that time somebody else has filed provisional patent. Forget about, he don't have device with him. आपके पास डिवाइस है, उसके पास डिवाइस नहीं है, लेकिन आपके डिवाइस के पहले उसने प्रोविजनल पेटेंट फाइल किया है. So he is going to be ahead of you. So therefore the prior date, the date of first disclosure, so this is what is very important. And whenever you are having innovative idea, like the following parameters are going to be tested for novelty. Prior publication, मतलब ऑफिशियली कहीं पब्लिश हुआ क्या, prior public knowledge, मान लो आपने जैसे कि मान लो मैंने फाइल किया, so there would be public notice. पेटेंट ऑफिस क्या करेगा, पब्लिक नोटिस इशू करेगा, कहेगा कि भाई दिस XYZ person has filed the patent, is there anybody who is having any objection? तो आप जाकर ऑब्जेक्शन ले सकते हैं कि नो दिस आइडिया आई डू हैव, यू नो, आई स्टार्टेड वर्किंग ऑन दिस एंड आई हैव सम proof that before his date of disclosure I have disclosed this idea, so your claim is going to be invalid. And therefore you need to be very sure whenever you are having innovative idea, don't disclose that in public. Don't make, you have to ensure that it is not in public use. Don't display it, राइट. स्टूडेंट बहुत बार गलती करते कि भाई उनके पास अगर कुछ प्रोजेक्ट है इनोवेटिव लगा तो he or she is going to participate in many competitions, so it will be in public domain. If you are displaying it, it will be in public domain. So what my suggestion would be, if there are some student attending this webinar, then for them my suggestion would be, if you are having innovative idea, आपके दिमाग में आइडिया आई, you go ahead and file the provisional patent first. Okay, lab आप experiment बाद में करिए, आप you file provisional patent so that date of first disclosure will be, you will be protecting your date of first disclosure, right? So this is very, very important as far as novelty is concerned, right? And as I mentioned earlier, discovery may pass novelty test but may not be patentable still. जैसे मैंने एग्जांपल दिया ना कि गुलाब जामुन है, पहले एग्जांपल दिया, गुलाब जामुन मीठा होता है हमें पता है, लेकिन आपने क्या किया, उसमें मिर्ची डाल दिया, so it is going to be new, it is novel. गुलाब जामुन, मेरा गुलाब जामुन तीखा है, novel. But whether it is non-obvious, तो क्या होगा, जैसे मैंने पहले बताया कि non-obviousness test is going to be conducted by the person who has got expertise in this area. Okay, तो जो expertise जो safe रहेगा, आम आदमी के लिए तीखा गुलाब जामुन नॉवेल होगा, बस safe रहेगा तो वो क्या कहेगा, अरे क्या बेवकूफ हो क्या. This is going to be tested differently because you have changed the ingredient, right? So it is obvious. If you are changing ingredient, test is going to be different. It is obvious. It's not non-obvious. So that kind of non-obvious test need to be. So you need to see whether whatever invention you have, whether it is non-obvious, right? So this is how the non-obvious test should be considered. And as far as non-obviousness is concerned, you need to understand scope and content of prior art. Prior art मतलब इससे पहले क्या scope था और क्या था. Assessing the technical results or economic value achieved by the claim invention. जो ऑलरेडी इन्वेंशन है उसका टेक्निकल रिजल्ट क्या है, उसकी इकोनॉमिकल वैल्यू क्या है. आई एम गोइंग टू गिव यू वन एग्जांपल एट द एंड ऑफ दिस. डिफरेंसेस बिटवीन रिलेवेंट प्रायर आर्ट एंड क्लेम इन्वेंशन. आपका जो क्लेम है और प्रायर आर्ट है उसमें क्या डिफरेंस है, वेदर इज देयर सब्सटेंशियल गैप, वेदर दैट गैप कैन बी ब्रीच बाय ऑर्डिनरी पर्सन. क्योंकि जब आपका एग्जामिनेशन होगा, जब आपका पब्लिश तो हो जाएगा, बट whenever you will be going for examination, the patent officer, the expert, subject expert is going to see whatever gap is there, like prior art and your own claim, whether that gap is going to be breached by ordinary person, ordinary skill. If it is true, your patent is not going to be granted. So that you need to ensure right in the beginning. And as far as industrial applicability is concerned, as I mentioned earlier, industrial applicability is defined as the invention shall be capable of having industrial application. Means like whatever product you are talking about, whatever processes you are talking about, it should have some application. You need to show that this process can have this and this application. This product may have, this is the application area. Unless you prove this, your patent, you are not going to have the patent granted. So there are three criteria: novelty, non-obviousness, and industrial applicability. Now, what invention not patentable? What are the invention which cannot be patented? Let me tell you some example. Invention that claims anything obvious or contrary to natural laws, like perpetual motion of the machine, right? अब हमें पता है कि state in which the moment or action is or appears to be continuous or unceasing is called as a perpetual motion. This is contradictory, क्योंकि हमें न्यूटन्स लॉ ने बताया कि ऐसा हो ही नहीं सकता. So if you are claiming like this, it's not going to be granted. Invention whose commercial exploitation could be contrary to public order or morality, which causes serious harm to the human, like adulteration of the food. आप अगर फूड में कुछ adulteration करके टेस्ट बदलने की कोशिश करोगे, so that cannot be acceptable. Moreover, the mere discovery of scientific principle, जैसे कि आपको पता होगा boson particle, at least whether you are from science or not, you are from science discipline or not, लेकिन 2012 में एटलास और CMS लेबोरेटरी ने जो एक्सपेरिमेंट किया बोसॉन एक्सपेरिमेंट बोसॉन पार्टिकल का, that you know, but that was predicted long back by Peter Higgs in 1964. But at that time उन्होंने theoretically propose किया था, right? तो पेटेंट नहीं ले सकते थे. But now they have somebody else have experimentally proven in 2012. So now they can be, I don't know whether they got patent or not, but whenever you have something in hand, in product form, that can only be patented, right? Claim for any scientific discovery, absolutely not. Even highest revolutionary scientific theory, कितना भी क्यों नहीं होता पेटेंट नहीं मिलेगा. However, such principle when result in substance, मतलब आपका scientific discovery है, उसका अगर एक product form में आप convert कर पाओ, whatever theory you have formulated, if you could convert that theory into product, then it can be patentable. Mere discovery of कुछ example और है. Mere discovery of new form of known substance, मतलब आपका known substance है, उसका form बदल दिया आपने, या तो आपने कुछ चेंज करके वो सब्सटेंस वही है उसकी प्रॉपर्टी चेंज कर दिया, दैट आल्सो कैन नॉट बी पॉसिबल. एक कॉमन एग्जांपल देता हूं आजकल का. हाइड्रोक्स की क्लोरोक्विन टैबलेट जो है, हमें पता है कि इट इज बीइंग यूज्ड टू प्रिवेंट और ट्रीट मलेरिया कॉज्ड बाय मस्किटो, राइट? दैट वी नो. But nowadays you must be knowing that India has substantially exported this tablet, this medicine to US and many countries, and we earn a lot of revenue out of that. But if the same combination is being used for treating COVID-19 patient, it cannot be considered as invention, right? And therefore it cannot be patented. This is just an example I have quoted. सिमिलरली जैसे कि हमारे पास वायरल लोग कहते हैं कि कोविड-19 ये वायरस है, इसके ऊपर वैक्सीन आएगा, लेकिन आई एम डाउटफुल वैक्सीन शायद कभी आए. At present, as Russia ki professor, I don't know whether he has joined because Russia has already claimed that they come up with vaccine. I don't know what is the reality because this is what we got from media. But let me tell you, my friend, the whatever viral infection we are having, we don't have any medicines, right? Even today, हमें जब सर्दी जुकाम होता है तो उसके लिए मेडिसिन नहीं है. इट्स इंक्यूबेशन टाइम फॉर 7 days. हम क्या करते हैं, मेडिसिन क्या पैरासीटामोल किस लिए थे, उसके साइड इफेक्ट सब्सिडाइज करने के लिए मेडिसिन लेते हैं. Otherwise, virus is going to be there for at least 7 days. That is why doctor हमें advise करते हैं कि be at home, take rest, be away from other people, so that you can protect other people from virus because it's contagious, right? So it's going to be there for 7 days. वैसा ही इसका 12-13 दिन का incubation time है. So we never know whether it's going to come or not. But anyway, another example, like mixture of sugar with color. आपने मान लो एक शुगर लिया, पानी में कुछ कलर डाल दिया और आप कहेंगे कि सॉफ्ट ड्रिंक बना दिया. नो, इट कैन नेवर बी कॉल्ड एज ए न्यू इन्वेंशन एंड कैन नॉट बी पेटेंटेड. Then like arrangement and rearrangement of or duplication of known devices like umbrella with fan. आपने क्या किया, अम्ब्रेला है उसमें फैन लगा दिया, आप कहने लगे कि भाई ये एयर कंडीशनर है. नो. बकेट फिटेड विद टॉर्च. आपका बकेट है, जैसे देहातों में लोग आपको पता होगा कि टॉयलेट की बाहर जाते हैं रातों के समय, और राइट, तो उन्होंने बकेट डिवाइस किया, उसमें एक टॉर्च डाल दिया एंड दे स्टार्टेड क्लेमिंग दैट दिस न्यू डिवाइस. नो. सिमिलरली न्यू फॉर्म ऑफ नॉन प्लांट, इम्प्रूव्ड सॉइल थ्रू फीडिंग फर्टिलाइजर. हमें पता है कि देहात मतलब खेती में हम फर्टिलाइजर फीड करते हैं, एज रिजल्ट ऑफ दैट वी कैन सी द इम्प्रूव्ड सॉइल, राइट? दैट कैन नॉट बी रेफर्ड एज इन्वेंशन एंड कैन नॉट बी पेटेंटेड. सिमिलरली, ये तो मैंने पहले ही बताया आपको, लिटरली ड्रामेटिक म्यूजिकल आर्टिस्टिक वर्क, मेयर स्कीम ऑफ रूल, मेथड परफॉर्मिंग मेंटल एक्ट, प्रेजेंटेशन ऑफ इंफॉर्मेशन, जैसे कि मैं अभी इंफॉर्मेशन प्रेजेंट कर रहा हूँ, इट कैन नॉट बी पेटेंटेड. मेरी स्टाइल में पेटेंट नहीं कर सकता. टोपोग्राफी ऑफ इंटीग्रेटेड सर्किट, इन्वेंशन अफेक्टेड बाय एग्रीगेशन ऑफ ट्रेडिशनल नॉलेज, दैट आल्सो कैन नॉट बी डन. And atomic energy act जो है, accordingly there are some areas in which you cannot have the patent, right? As far as the amount is concerned, the charges are concerned, whether it is provisional or the complete specification, you need to pay 1,600 rupees, only 1,600 rupees for individual, right? If you want to have the early publication, then 2,500. If you want to request for examination, another 4,000. So this is the only is that you have to pay whenever you are submitting patent. However, if there are extra seat for initial 30 seat, It's free, but if more than 30 seat, 160 rupees per seat. And if there are more than 10 claim, for 10 claim it is free. More than 10 claim, then for per claim it is 320. So on an average, if you want to file provisional patent, 1,600 rupees. Complete specification, 1,600 rupees. Now let us go for, I'm going to tell you the glimpses of the drafting of the patent. So this was all awareness. I thought let me go beyond that and tell you like some tips for. But let me tell you, my friend, by listening only half an hour lecture, you will not be able to earn that kind of skills or expertise for drafting patents, right? So this is going to be a kind of awareness for you that this is not a difficult job. This is not an impossible task, right? This is what my message is going to be. So kindly take in that fashion. So what is filing patent? The process of submitting an application in a patent office requesting grant of patent to your invention is nothing but the filing of patent. If you wish to protect your invention in different countries, then you will have to submit patent application in each of those countries. There are various options for or approaches you may use to protect your invention in one or more countries. I am going to tell you what are those options. First of all, what you need to do actually, right? Every bit of information regarding your invention. So whatever invention you have, you please collect all the information with you. Every bit of information regarding a specification. I'm going to tell you what is specification. In order to protect the priority date, this is what I have earlier suggested also. You to again, I'm going to advise you. If you really want to protect the priority of any particular invention, there is a provision that any idea, even at its most premature level, can be filed. जैसे कि मान लो आप एक डिवाइस डेवलप करना चाहते हो, just premature idea आपके दिमाग में आए, that premature idea can also be protected. Let me tell you, you can go ahead and file the provisional patent. जैसे मैंने पहले बताया ना कि आज के डेट में आपके पास आइडिया आई, and if you start thinking of doing some experiment and later thinking of submitting patent, by that time क्या होगा, किसी के आप एक्सपेरिमेंट करते करते किसी को ध्यान में आएगा कि आप क्या कर रहे हो और उसी टॉपिक पे कोई प्रोविजनल पेटेंट फाइल कर देगा, then you are going to lose the novelty. And therefore you need to be very sure that whenever you have some innovative idea in your mind, go ahead and do the provisional file the provisional patent, and then you are going to have 1 year time, right? Once we are having complete information regarding invention, you can go ahead and do the file the complete specification, क्योंकि आपके पास the provisional के specification submit करने के बाद कम से कम 1 साल रहेगा जब तक आप आपका patent file कर सकते हो. What are the options? Filing provisional patent application in India, complete या provisional या complete, filing patent application in foreign country, convention filing. This is what you call as convention. आपको बाहर जाना नहीं है, करना तो यहीं पर है, तो उसको हम convention filing कहते हैं. और you can do patent cooperation treaty, PCT. अगर आपको एक बार मान लो under PCT, you can file your patent under 170 country, almost approximately 170. मतलब आपको अगर आपका jurisdiction 170 कंट्री का jurisdiction आप करना चाहते हो, तो then you should go ahead and do the PCT. और convention में because there is a convention, right? Convention countries, there are like around 10 countries which comes under convention. आप अगर convention category में file करोगे तो jurisdiction वो 7, 8, 10, 12 countries रहेंगे. PCT में all those countries, more than 100, I don't remember the exact number, more than 100. Or you can go ahead and file the ordinary file that only jurisdiction you want to be in India only. Filing provisional patent, let me tell you more about the provisional patent. Provisional patent application is filed to secure priority date for your invention. This is very important. आपका जो priority date है उसको secure करने के लिए सबसे पहले हम provisional patent, otherwise दूसरा कोई मतलब नहीं. Priority date is the date on which the first patent application for invention is filed. जैसे कि आज आइडिया आई, कल आपने provisional patent फाइल करने के लिए आप ऑनलाइन फाइल कर सकते हो. उसके लिए आपको किसी पेटेंट अटर्नी की जरूरत भी नहीं, किसी की भी जरूरत नहीं, टेक्निकल एक्सपर्ट की जरूरत नहीं है. आप आज के जो इंफॉर्मेशन दे रहा हूं, ऑन द बेसिस that information also you should have your own digital key, and that's it. You can, if you are having today digital key with you and some innovative idea with you, next moment within 10 to 15 minutes you can go ahead and file your provisional patent. That would be your priority date. that will be a prior date of first date of disclosure. The date is important because knowledge available in public domain before priority days is referred as prior art. This is very very important. Prior art का जो concept क्या है कि आज के डेट में, जैसे मैंने फिर से रिपीट करता हूँ कि मान लो मैं एक दिन अगर पीछे रह गया, मान लो आज मैंने मेरे दिमाग की जो आइडिया मेरे दोस्तों के साथ मैंने डिस्कस की, right, and my friend is wise enough to file provisional patent today only, and then tomorrow I started filing provisional patent, is not going to be novel because today I will be filing tomorrow. My friend has filed that provisional patent today, so that is going to be prior art, and I will be losing novel. That need to be this issue need to be tackled very seriously. If you delay filing patent application, then naturally more knowledge in the public domain gets added to the prior art, and hence decreasing the probability of patent grant to your invention. So therefore, there is a significant importance of filing provisional patent. As far as complete patent application is concerned, complete patent application has to be filed in the patent office in India if you wish to protect your invention in your in India, jurisdiction of India. Complete patent application can be filed in the first place, मतलब directly भी कर सकते हो, otherwise अगर आपने provisional patent पहले file किया हो, तो then after 12 months, like if you let us say January 2020, if you have filed the patent, provisional patent, then January 2021, before January 2021, you have to file your complete specification, otherwise your claim is going to be invalid. Filing convention patent application can be filed using this option. Again, convention means what? Instead of one country, there will be a group of countries, right? There are also same option. You can go ahead and do the provisional, and after 1 year, you can do you can file the complete specification, or today itself you can file the complete specification. As far as PCT is concerned, what does the PCT means? Patent Corporation Cooperation Treaty. This assists applicants in seeking patent protection internationally for their invention, help patent offices with their patent granting decision, and facilitate public access to wealth of technical information relating to those inventions. It means what happens? Like, let me read last line. By filing one international patent application under PCT, applicants can simultaneously seek protection for invention in larger number of countries. Whatever the group is there, let us say more than 100. So by single application, your jurisdiction would be those many countries. Of course, the charges would be more. Now let us talk about the specification. So there are two different kinds of specification: provisional specification and complete specification. Now what is basically a specification? Let me tell you something about that. Patent specification is a document through which an inventor discloses the details of his invention to the patent office. मतलब क्या है? Specification मतलब क्या है? उसकी details disclose करना, nothing else. I'm going to show you my own example, right? Patent specification is a techno-legal document. Techno-legal document, it is going to have a technical document, legal document as well. And therefore, my friend, let me tell you, we could be good in techniques. Like we could be good in, like, let us say I come up with one sensor device, right? So I'm having expertise in the sensor, but I may not be having expertise in drafting legally, right? So will be having some problem. So if I'm still trying to draft patent on my own, I will be having some problem, right? So you need to remember that this is the language used in patent specification has a combination of technical and legal jargon. It's not only technical, it's a combination. So therefore we need to be very sure about that. What is patent drafting? It is the drafting of specification that constitute the everything of patents. Now what is that? Is really heavy? Yes, it is true. We should be very, very, very careful. Most critical step in filing patent. Poorly, let me tell you, you need to be very clear about this. Poorly drafted specification can lead to revocation of your potential claim. मतलब आपका अगर draft सही नहीं है, आप जो claim कर रहे हैं, वो claim भी cancel हो सकता है. Because whenever you are claiming, we are writing claim is not only technical language, it is a legal language. आप एक claim से नहीं चलेगा आपको, क्योंकि आप अगर एक claim करोगे, so the other person is going to, file the patent on the same device with different claim. Let me tell you, my friend. So you will be handicapped. So all possibilities need to be explored, and technical हमें देखना पड़ेगा कि legally कितने languages में same claim को हम represent कर सकते हैं. So therefore, that is why there are more number of claims, right? Claim that is not strong may be granted patent only because of good judicial land drafting. मतलब अगर आपका technical उतना strong भी नहीं रहा, but if your judicial language is very correct, very strong, although it is weak, still it can be granted. Therefore, more than technical documentation, it must be remembered that it is a techno-legal document that you need to remember. And therefore, all tightening or sharpening tools need to be exploited, explored before we go for the filing patent. So there are two more points. What is invention? I already mentioned, but still let me repeat it again. Invention means a new product or process involving an inventive step and capable of industrial application. That is very, it's not only new, it should have industrial application. So it could be fundamental research, or it could be improvement of existing art. It could be, you could be solving unsolved problem, or it could be like different approach. You will be having different approach. Now, what is public domain? Public domain का मतलब क्या है? Like known to the person in the art, मतलब आप जो concept बता रहे हो किसी को पता है, right? Common general knowledge is available in public knowledge. It could be in the published form, or it need not be in published form, right? There is a person who has got substantial proof, knowledge of that, the invention which you are talking about. He can go ahead and he can challenge your claim, right? Because it is always going to be in public notice, and whenever he is doing that, you are going to be in trouble. And therefore, before you start, you need to understand what is invention, whether you are talking about product or process, whether your invention is patentable, whether it has got novelty, whether it is inventive, and whether it is prior art, prior disclosure. Whether somebody has disclosed, you forget about somebody, whether you have disclosed it orally, whether you have printed earlier, whether you have displayed in the public in front of any audience, or whether you have asked somebody to use before you file the patent. So this need to be asked. And therefore, before you go for, again, I would like to advise you to conduct search. This is the search. So you can write this ipindiaservices.gov.in. This is one of the patent search website. Like whenever you are drafting patent, first of all, you need to search so that you can, at least the novelty search can be one aspect. This is like one aspect of novelty search. Then at least the problem in the prior art, whatever prior art is there, you at least the problem. What is the problem sought to be solved by your invention? Invention means whatever knowledge is there, whatever devices are there in the public domain, what are the problems, what are the limitations, whatever device you have come up with, what kind of the gap what are the gaps, and whether you will be able to bridge that gap, what kind of novelty you have, is the solution is obvious, because this is also very important, has the publication ensure, and unless you do this, you should not go ahead. And you should be very strict to your own examination, because you need to be very strict own examiner. You need to do very serious viva analysis of your own invention. Bring out toughest examiner inside yourself, and ask yourself whether your invention is patentable. And because you are going to be the best person to know your invention. If you don't do this, be ready to waste the money. Because otherwise, if you are not sure about all these questions, then you are going to waste your time, as well as you are going to waste your energy. You are going to waste the money as well, because it's not going to be granted. Now, if you are ready, then you can start. Now, what is mean by filing patent? There are three different forms. Form 1 is always to apply Control General patents for grant of patent. This is just an application. Form 2 is the actual provisional or complete specification, and Form 3 is undertaking. And this is the if you really want to have the guidelines, this is the website www.ipindia.nic.in, on which you can get the more information. This is the format of provisional specification. You can see title of invention. This is the form number 2. This is very, very critical. Form 1 and 3 are just an information. Form 2 is a real face job you will be doing. Title of invention, applicant name, nationality, address, preamble to the description, and then what is from next page, field of invention, background of invention, object of invention, general statement of actual invention, and most importantly, claim is not going to be required. So this is what the format. I'm going to show you my own example. This is the format of provisional specification. Now let us see provisional specification. I have already mentioned about this. I'm going to tell you what are the advantages to get the priority for the this also we have already discussed. Let me skip those slides. Now this is real example. So I said title is the first you should start with the title. This is the actual patent which we have filed, and so far it is published, already published. This is the title. And annunciator for pernicious presence of ammonia in air. This is the application. Myself is applicant. There are many inventor. These are my students who are inventor with me. And then preamble. What is preamble? You have to write just like this. The following specification describes the invention. Then description. What is this? The field of invention. What is this? This invention is related to the development of a smart alarm annunciator that is designed to sense ammonia in ambient atmosphere, and then blah blah blah. So this is the field of invention you have to write. The next is background of invention. Ammonia, you can see I'm not going to read entire thing, but one statement I'm going to read. Ammonia detection gadget devices that are available in market. You can see whenever you are talking about background, you need to see like what is there in the background. Available in the market are mostly based on electrochemical sensor and or metal oxide sensor that have higher power consumption than the device being exposed, and also the commercially available devices are costly. So these are some of the issues I am talking about in the prior art. Then this is object of invention. These objects are going to be very, very important because this is provisional specification, and whenever you will be filing your the complete specification, these objects are going to be very, very important to have the claims. Therefore, you can see I'm going to read only first object. The principal object of this invention is to propose low-cost device that can detect the presence of ammonia at the pernicious level at 35 ppm as defined by OSHA. So like that we have the three different objects, and then this is the statement of invention. Next is ammonia sensor available in the market are too much costlier, like this. So again in the statement of invention also we are going to highlight what are the issues of present art, prior art, and what are the gaps and how we are going to bridge the gap. Okay, and then this is what the provisional patent draft is, and once you submit, you are going to have this kind of receipt. This is what we have filed in the year 2017, you can see, and then in 2018 we have filed the complete specification. So earlier we went ahead and filed the provisional patent, and then we went ahead and filed the final specification. It was in 2018. You can see it was filed, because you can see the date of first filing was January 2017. Complete specification were filed in January 2018, and then it took almost 5-6 months for the publication. Now we are waiting for the the examination. We are going to submit the fees for examination, and then they will be calling us for examination. Now as far as the complete specification is concerned, what the complete specification, I'm not going to tell you the details, but I'm going to tell you some glimpses, 2 to 3 slides, last 2 to 3 slides. The complete specification will have, it should have fully, and it should be fully and particularly described invention. In complete specification, in the provisional, you're not going to describe totally. It's kind of very brief information about what you are going to have. You are going to highlight what are the shortcomings of prior art, and then you are going to mention how those gaps can be breached by your invention. A small, very, very preliminary information. But as far as complete specification is concerned, you have to give full information of what kind of invention you have. You should disclose the best method for performing invention which is known to the applicant. Whatever invention you have, what kind of methodology you have used, that need to be mentioned very, very thoroughly. And then whatever claims you have, because that is also very, very important, all claims need to be mentioned in complete specification. And this is the format. I'm going to tell you only format because I don't have adequate time to go through the details. You can see this is the format of complete specification. Title of invention, applicant's name, nationality, address, preamble. Preamble is going to be this only. The following specification particularly describes nature of this invention and the manner in which it is to be performed. And then on next page you have to start, because technically you cannot start from the same page, you have to go to the next page. And then from next page you can see here you have to give the details of field of invention. You remember now, here you have to give them all those details, prior art and its drawback. That means what kind of devices are there, all those devices you need to mention, what kind of shortcomings of the devices you need to mention, background of invention with regard to prior art, means how you come up with the idea, like with respect to the gaps, how you come up with this idea. Then statement of invention, how those gaps, whatever gaps you are identified, how those gaps you are going to bridge here. And the brief description and referencing of accompanying diagram, drawing, whatever the drawing you will be having, that need to be described in detail, very specific. There is some format, specific format of giving drawing, all those labeling and description of all those labels. Then detailed description, as I mentioned, advantages of invention, what kind of advantages you have, and then what are the claims. This part is going to be very, very important. It's not going to be only single claim, there would be series of claims, because if you are having only single claim, it will be very difficult to protect your invention. So you should have at least 10 to 15 claim of single invention. And then if you are having description, the detailed drawing was there, here you can give the additional drawing. And then abstract of the, here you can give the abstract, the what in abstract, whenever you are talking about abstract, you need to mention what you have done, how you have done, and what you have achieved. There is very smart. It should be very effectively written. It should not be too much lengthy. There should be 3 paragraphs in the abstract. 1 paragraph will describe what you have done. Its second paragraph will describe how you have done, and third paragraph will describe what you have achieved. So this is how the complete specification can be filed. And in summary, let me tell you, my friend, because I have taken a lot of time, intellectual property rights provide exclusive right to the inventors, provide legal defense, and offers them incentives of their work, help in social and financial development as well. And let me tell you, my friend, honest, committed, and focused efforts are always required for skillful drafting of patents. Because if you are not honest, if you are not committed, if you are not focused, your energy is going to be wasted, your time is going to be wasted, you are going to waste your money, because your patent is not going to be granted. And therefore, thoughtfully drafted patents will always lead to a quality document which will have novelty as well as societal relevance as well as industrial applicability as well, and it can be easily accepted. And with this, I'm going to stop here with a wonderful quotation of Steve Jobs. Great things are never done by one person, they are done by a team of people. And same thing is applicable here as well. Whenever we are talking about innovation, whenever we are talking about invention, whenever you are talking about whatever, research, it's a team activity, it's a group activity. Unless you have a group, unless you have a team of people working together, you cannot have the miracle. And if you are having the team of people working together, miracle is bound to happen, and you are bound to get appropriate rewards. With this, I would like to once again thanks organizer for giving me this opportunity to share my experiences.